Good morning, ma'am. Are you Ashley Brousard?
Yes, ma'am.
And Ms. Brousard, in cause number 25 DCCR 0175, you're charged with the third-degree felony offense of injury to a child from October 28th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand? And I have here on the computer a plea bargain rejection that you've signed with Mr. Kimler that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 5-year deferred probation, a $500 fine, and you would be required to follow all of the rules and conditions of probation. Also, I'm sure Mr. Kimler went over with you that that type of probation, if you're successful, means you don't have a felony conviction on your record. Do you understand? You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial? All right, we'll get that done. I also want to make sure, Ms. Brousard, that you understand that after today, I will not accept this plea agreement. If you change your mind to want to plead guilty, you can plead open to the court. It could be to some different agreement, but it won't be this one unless there's some new information that your attorney or Mr. Smith gets between now and trial. Do you understand? All right, then I'll get it set on
The events made the basis of this case and the arrest, I think 3 or 4 months right along, when CPS was investigating the case where she had custody of the child, or at least was visiting the child.
They were with me up until the arrest.
what?
With CPS.
Y'all can't both talk at the same
With
time.
CPS supervision without any problems. Then when she was arrested, there was a condition of bond that she not have any contact with the child. CPS doesn't have any issues with her having visitation or contact with the child. We were just asking the court remove that bond condition because it's impacting her relationship with the child, and I think the child's development. How old's the child? 3 years old.
Do you mean just a second? Can you hand me that up when I'm printing, please?
Who was the CPS investigator? If you have any questions for her, we can run it over.
Mr. Smith?
If Mr. Smith has any questions, we can run it over.
No, I'm asking what your position is.
It's opposed, Judge. And again, I would just observe that there was about approximately 4-month period prior to her arrest. There were no incidents.
But that was,
There's a co-defendant in this case, Dalvius Williams. We had a hearing on this. I believe it was an MTRP on Mr. Williams. So you've seen the evidence in this case. I don't know if you recall it, but the child was 2 years old and nonverbal. Showed up at school Friday, everything was fine. Shows back up, misses Monday, shows back up Tuesday. The marks are there, and allegations are that those were the only people around her at the time.
And I would just observe that there was a CPS investigation subsequent to that where the child remained in contact with the defendant with no deleterious consequences reported.
no, what consequences?
Bad consequences.
No,
Harmful.
what's your word?
Deleterious.
It's not gonna be my word of the day to learn.
It's one of those SAT vocabulary words.
It's been a long time since I took that. I'm trying to recall that hearing. I feel like that Mr. Williams was maybe more culpable with regard to the specific allegations, not necessarily not turn them in and things like that, but the actual physical.
And then when the police started the investigation on this, she lied to the police.
Allegedly. She didn't cooperate. We can agree on that. It was non-cooperative.
The only thing I will do, I will modify the bond condition that you can have contact with the child, but it is only to be supervised. So you are never to be alone with the child, period.
Is that through CPS supervision or is the supervision?
I don't, If CPS isn't involved, I can't order them to supervise. So y'all work on figuring that out, but there has to be another adult, of some adult at all times, not a 16-year-old, an 18-year-old, someone.
Grandma didn't live with grandmother, so I'm sure she.
Okay, perfect. Then I'll let you have visitation so that you can, obviously, I think this is something you will be able to get past. You'll be able to hopefully work towards more than just this, but I want to start off with me feeling comfortable with that until we figure out what's going on in your case.
Your Honor, just
Okay.
in the interest of specificity, she's only to have contact with the child in presence of the grandmother. What's the grandmother's name?
Dana Williams.
She's
Okay,
only to have contact with the child in the presence of Dana Williams.
okay, yes, that's the order. Thank you, Mr. Kimler.